Ministry of Industry, verge of finalizing our new plant varieties, that is Rights of Breeders Bill, and bringing it into law. Apply to register their new varieties and to obtain plant breeders' rights for a breeder, the scope and duration of those rights of the breeder, and exemptions to those rights. Persons or entities holding a plant breeder's rights certificate will be able to exclude others from marketing or selling a registered plant to now obtains with the use of trademarks, patent, investment, and commerce. Are pleased to support will be protected for 25 years, and other genera or species will be protected for 20 years. Importantly, the law will include an extended harvest from a protected variety for propagating purposes or their own land holdings, subject to the safeguarding of the legitimate interests of the owner of the plant breeder's rights. Under the new law, the carrying out by a person without the authorization of the breeder of any act which requires the breeder's authorization shall constitute an infringement of the breeder's rights, which infringement shall be actionable in the court by the holder of that breeder's right. Provision will also be made for the enforcement of plant breeders' rights through criminal and civil sanctions, such as fines, damages, injunctions, forfeitures, failure of or destruction, seizure or destruction of propagating material, and imprisonment, where breeding programs and lead to increased exports, very important for Jamaica, will lead to increased exports and revenue generation from new plant varieties. It's important that as a country of this size and an economy of this size, that we look wider field. It will also improve Jamaica's food security and sustainable agriculture and contribute to increased income generation from agriculture. The impact would include increased improved health conditions of the population. With we recognize that there is an urgent need for legal varieties of cannabis plant. Protection will be available for any type of cannabis plant, and private plant breeders and researchers in Jamaica will be able to exploit the relatively low technological barrier needed to qualify for plant breeders' rights. Over time, as new cannabis varieties stabilize and growers increasingly move away from cloning and more into breeding new varieties, the PVP system will be pivotal for the protection of seed propagated cultivars. The government of Jamaica therefore takes seriously the opportunities that exist nationally and globally for expansion of plant breeding in cannabis and other plant varieties. Jamaica, through the Jamaica Intellectual Property Office, has done considerable capacity building work with UPOV over several years in preparation for implementation of a sui generis plant variety protection system. The UPOV Secretariat and the UPOV Council have reviewed Jamaica's draft law and has confirmed that it is in conformity with Claire and her team at JIPO. Let me therefore take the opportunity to thank JIPO, Jamaica Intellectual Property Office, the UPOV Secretariat, and the UPOV Council for their commitment and support to Jamaica in providing technical assistance to this point of achievement. We look forward to continued cooperation and support from UPOV in the ministry's implementation of the new law, and wish to assure JIPO, the Ministry of Agriculture and Fisheries, and UPOV of the continued commitment of the Ministry of Industry, Investment, and Commerce in this very important developmental initiative. And many thanks to JIPO. And thank you all so very much. Lily Claire, are you on mute?
Thanks, Minister. Thank you, Minister. Thanks so much for that really excellent articulation of the benefits to Jamaica that will accrue from the new plant breeders legislation. And also for we look forward, as you said, Minister, to working closely with the Ministry of Industry, Investment and Commerce, the Ministry of Agriculture and Fisheries, which has a critical role to play in this new legislation, and
Indeed.
also with the UPOV Secretariat. Thank you so much for joining us, Minister, because I know you have a really packed schedule, and I really
I'm off.
appreciate. I know I really appreciate you taking the time, because I know you have another appointment. So thank you so much, Minister. We will be in
Thank you,
touch.
Lily Claire, and all your guests. I appreciate it, and very good luck. And you know you have mine and the ministry's support. Thank you
Thank you,
so much.
Minister. We appreciate it. Have a great day, Minister.
And you
So I
too.
would thanks, Minister. At least this time, I'd also, as Minister alluded to, I'd like to acknowledge the presence of representatives from the World Intellectual Property Organization, the European Union Intellectual Property Office, and our colleagues from the Caribbean and our own Jamaicans who have all joined us. Has worked really closely with the Jamaica Intellectual Property Office and the government of Jamaica. He's head of technical affairs and regional development for Latin America and the Caribbean from the International Union for the Protection of New Varieties of Plants, commonly referred to as UPOV. Leontino is an agronomic engineer. He has a postgraduate degree in plant breeding and agribusiness administration, and he worked previously in plant variety protection from around 2002. He has been at UPOV since 2012, and he previously worked in the private sector in an area that is also important to Jamaica, ornamental plant breeding and production. And he is a friend of Jamaica. Leontino, thank you so much for joining us. I know it's afternoon.
Everyone, I'm speaking. Miss Bellamy, Mr. Parker, Mr. Chocolate, dear colleagues, it's a pleasure and an honor to be here with you today. I hope you are seeing my screen. I am sharing a short PowerPoint presentation, which I intend to deliver in less than 20 minutes. So if this is the case, I will just proceed to the first part. This is a brief overview of what is UPOV in case any of you would not be so familiar with UPOV. Our mission is to promote the development of new varieties of plants, and we do so through an intellectual property system that's been created specifically for developing new varieties, for addressing intellectual property for new varieties of plants. And this means that the breeder which protects a variety is entitled to control or in this case, to authorize actions in relation to the propagating material of its variety, of their variety. So to produce, to condition, to offer, sell, export, and import the propagating material of a protected variety. But in practical terms, it means that this is one added layer of options for farmers to choose from. Farmers will retain the possibility to select and to use, according to their will, land races, wild populations, and also old or unprotected varieties, including new and protected varieties as the top of the pyramid where more knowledge has been added. And these varieties are regulated by the UPOV Convention, whereas all the other planting materials are not regulated by the UPOV Convention. They may be regulated by other pieces of legislation, but these do not apply to plant variety protection under the UPOV Convention. UPOV members are all over the 5 continents, and you can see in this map there are 78 members of UPOV covering almost 100 territories across the 5 continents. But to become a member of UPOV, first you have to have a legislation in conformity with the UPOV Convention, which Jamaica has been very strongly developing and working in this area. We're very happy to acknowledge that the Jamaican draft law has been also has received a positive advice of the UPOV Council. So once the legislation is enacted, Jamaica will be in position to become a member of UPOV. But what does being a member of UPOV means? Well, it is not a one size fits all. The annual contribution that a member must provide is the value of the contribution unit is 53 Swiss francs, 53,000 Swiss francs. This could be equivalent to some 53,000 US dollars, just to give you a close. Randomly picked a few of UPOV members just to show how much each of these members contribute to the budget of UPOV. The contribution unit, the entire contribution unit being 53,000 Swiss francs, the minimum level of contribution is 20% of a unit. So several UPOV members contribute with the equivalent of 11,000 US dollars as with the 0.2. Other members, they understood the value of our work, and they support UPOV with different levels of contribution, 0.5, 1, 2, and some UPOV members, but also the US, contribute to our budget 5 units. But moving on to more practical terms, people ask me, what's the impact of plant variety protection? So I went over to the supermarket here besides where I live, and I took a couple of pictures of the same product, originated both from old and not variety, with value of 3.2, 3.3 Swiss francs or US dollars, whereas to the right hand side, value. Let's come closer to Jamaica and fly over to Peru. I apologize for the slide in Spanish, but if you're not familiar with Spanish language, maybe we should start with the most important word, which is million. And in this slide, you see the red bars displaying a growth in 10 years from 60 million to $500 million in exports of table grapes, and largely due to the use of new protected varieties. More important or more impressive is the value. A nice lesson in Spanish, billion in times, $1 billion in exports. I won't bother you more with slides in Spanish, but also moving over to another example in the region, Mexico. Since joining UPOV, Mexico has received varieties and investments from more than 200 breeders that came not only from Mexico, but from other countries, in this case, 26 other countries. And this means that almost 3,000 new varieties were made available to farmers. Over time, these intellectual property titles, they are extinguished, and the varieties fall under the public domain. And you see that from 3,000 varieties that had been protected, today some 400 are free to be used and under the public domain, thus showing the benefit for Mexican society. I'd like to use an example from Japan because it relates somehow to the topic of the ganja industry. In Japan, rice has aroma. Aroma is an alkaloid that is very much linked to the territory, the variety, and in Japan, to maintain the aroma, to maintain the high expression of those particular alkaloids like CBD or THC in ganja, the Japanese association used a plant variety protection strategy to control who could grow that variety so as to maintain the level of expression of the aroma of their variety. When they reach the marketplace, that variety with a higher aroma has a better benchmark variety. But of course, plant variety protection itself will not resolve the issues, all the issues around agriculture, because plant variety protection does not operate in isolation. And plant variety protection or plant breeders' rights is concurrent, or it occurs in parallel to other intellectual property rights, patents, trademarks, and also variety registration requirements, biosafety regulations, phytosanitary regulations, criminal regulations, international trade regulations, all other laws that occur simultaneously before planting material reaches the farmer. Nonetheless, plant variety protection is a key element, a key component to attract investments and to spin a very positive wheel of innovation and delivery of planting material to farmers. All this is encapsulated in acronyms like PBR, Plant Breeders' Rights, or PVP for Plant Variety Protection, which is our mission. Once joining UPOV, what's seen in the region in Latin American countries having joined UPOV is that soon after joining UPOV, there's a spike in foreign varieties being brought to the internal market. And the trend evolves over time as locals take advantage of these foreign varieties being made available in their territory to develop their own varieties and become breeders themselves. In comparison to, in regional terms, if we look at Asian countries, if we compare Indonesia, Philippines, Malaysia, Vietnam, small countries in the Asian region, you see that Vietnam, being a member of UPOV, has been receiving an increasing number of requests for plant variety protection. This means more planting material, more varieties being made available to farmers. Whereas neighboring countries, not members to UPOV, receive a stable and rather low number of requests or filings for protection of new varieties. The moral of this story is that in Vietnam, the economical impact of having the best genetics available to farmer is that substantive increases in yield of staple crops such as rice, corn, and sweet potatoes have been noticed. But moreover, the economic impact is equivalent to some $5 billion or equivalent of more than 2.5% of their gross domestic product. Moving to Africa, we see the example in Kenya. Kenya, being a UPOV member, not only has increased the amount, the quantity of cut flower exports, but also the value, the added value over what they export. And here you see in this graphic, very stable, although not stable, but an ascending trend in value of their exports. And this also translates to jobs and employment. Of course, you cannot talk about the flower industry without talking about UPOV, because UPOV members represent more than 93% of all exports of cut flowers worldwide, including Colombia and Ecuador, nearby in the region. Anyone can be a breeder. We are not talking about any particular type of corporation. We're talking about anyone. A public sector institute, organization, university can file for protection, as well as an individual, a farmer, an association, a cooperative, as well as small, medium, and large-sized enterprises. Just to round up my talk, I just wanted to open this more technical part in case you would wish to ask questions as well on examination of candidate varieties, because a variety, as Honorable Minister has highlighted, must be distinct, uniform, and stable to be protected. And this is the DUS or field trial, the DUS trial of a field trial. And you have here just an image of what it looks like for this particular crop. The criteria being distinctness, so distinct from any other variety of common knowledge that is available worldwide, on the basis of characteristics that may or may not have commercial interest, such as here you have for apples the color of fruit. The variety must be uniform, and this is rather straightforward. If you are looking into a self-pollinated crop, you could be counting the number of OV types to assess a uniformity. And here you have the comparison between one variety that is uniform and another variety that displays a couple of OV-type plants for characteristics such as plant height and color of flower. But if you have an open pollinated crop or cross-pollinated crop, there are other methods to assess uniformity. And here, for example, relative tolerance limits are used so that you can still assess uniformity on the basis of a variety of common knowledge that is considered sufficiently uniform. So the candidate is compared against other variety or other varieties that are considered as sufficiently uniform depending on the type of propagation. Stability over successive generations. At the top row, a variety that is reproduced and does not segregate, retaining stability on the expression of its particular characteristics. And at the bottom row, you have a variety that after successive generations of propagation is segregating for the characteristic color of a flower. If you would like to learn more about examination of cannabis varieties, UPOV has harmonized internationally the test guidelines for cannabis sativa. This is freely available on our website. The web link is at the bottom of the screen. But in short, what this document provides is clear guidance on when to observe the characteristics, how to assess such characteristics, and exactly what should you be looking at, with explanations and example varieties to illustrate how the expression of the characteristic occurs. The US examination is largely performed in cooperation with breeders. Having access to your knowledge, to your facilities, also speeds up the process and lowers the cost of examination. So the authority may agree with the breeders to cooperate and develop the US examination jointly, or take into consideration the results of the US examination conducted by the breeders. Authorities may also choose to cooperate with other authorities, taking over test results instead of reconducting results, simply taking over results from examination previously conducted by other UPOV members, since we do have a harmonized system through the UPOV convention itself. What this means is that if a first application is filed in one member, a subsequent member can use the results of the US examination for taking their sovereign decision on whether or not grant a particular title. And UPOV suggests a value of 350 Swiss francs or US dollars for exchanging these test reports. For Jamaica, file for protection of Jamaican varietants to bring their varieties to Jamaica. UPOV offers an online application service. This is a website or an application that's available from the UPOV website, enabling all the breeders to file for protection electronically and submit these applications to all. To summarize my entire presentation with this slide, because breeders are developing new varieties for the benefit of farmers, growers, and consumers. And this is the transfer of technology that's encapsulated, the largest amount of quantity encapsulated in the smallest container, which is the seed. But breeders require support, and this support may be in the form of income to remunerate and maintain their breeding activities. If you'd like to learn more, this presentation will be made available to you, but I'll be happy to keep in contact with you. You're welcome to search through the guidance available on the UPOV website, and also to contact us on these email directions. On this note, I'd like to thank the opportunity, and I would really be looking forward to hearing from you. What are your questions, your queries in relation to what I have just presented? Thank you. Back over to you, Lilika. Thank you.
Thank you so much, Leontino. We really appreciate this. We're going to move on now, and we'll take the questions at the end just to ensure that we retain our audience for all of the presentations. So our next presenter is our very own Dr. Marcus Goff. He's the Deputy Director and Legal Counsel here at the Jamaica Intellectual Property Office. He's an attorney at law with over 20 years of experience. He has a Bachelor of Law degrees from the University of the West Indies, Cave Hill campus, and he has a master's and a PhD on traditional knowledge and traditional cultural expressions in the Caribbean. So I'm going to invite Dr. Goff to do his presentation now, and he's going to focus on the Jamaica's new law, the New Plant Varieties Rights of Breeders Bill. Marcus, over to you. Thank you so much.
Okay, thank you very much. Thank you very much. I think my camera seems to be disabled.
Oh,
Not
no.
sure why. Not sure if the face not looking enough this morning.
No, that's not true.
I'm gonna share a screen nonetheless and do the presentation. I did want to
Okay.
greet everyone as well this morning and say thanks for joining us. I'll just upload the presentation now. Right. Yes, please. All right, I think I got it now. Sorry for the delay. So you should be able to see the screen.
No,
now.
Marcus, we're not okay. It says it's loading.
See it now?
Yes,
All right.
it's up now. It's not in presentation mode, but it's up.
Okay, okay. I'm seeing it full screen slideshow mode, no?
On my computer, it's not in presentation mode, but if we can see it, so I think we should just go ahead.
Okay, all right.
All right, thanks, Marcus.
Sure. So we are very excited about this new law, and so I'm gonna just bring a summary about what it has in store for us. I understand it's not showing properly. All right, are you seeing the screen now?
No, not showing. Okay, Marcus is trying to, it started to, okay, it's back up. On my screen, it's still not in person, but I can see it. No, it's gone.
All right, I'll go share your screen and hopefully it will come up, or you'll be able to see it nonetheless. I can probably try to make it as big as possible. I can do the screen like that. We've had a private sector for several years, and with this new law, we hope that we can really accentuate the plant breeding program that we have here in Jamaica. Many persons, as we know, are actively involved in developing new plant varieties, and so the decriminalization of ganja in Jamaica in recent years, there's a need to have a framework that can protect the rights of breeders of new plant varieties. And so we're very pleased that we have this new law that is coming on stream very shortly. So introducing the New Plant Varieties Rights of Breeders Bill 2022. The New Plant Varieties Rights of Breeders Bill will recognize and protect, for the first time in Jamaica, the rights of breeders of new plant varieties in Jamaica. The background is that people breed new plant varieties for several reasons. They are capable of producing higher yields, for getting better product quality in terms of the output. Of course, better resistance to plant pests and disease. These are very important factors which, as we've known from history, can negatively impact plant breeding program or an agricultural sector. So being able to breed new plant varieties and focusing and spending and investing time and money to do so has a variety of benefits. Plant breeders' right actually is a new form of intellectual property right that we will be introducing, and it will be specifically for persons, for plant breeders who have developed or breeded newly bred plant varieties. And so for the first time, again, it will join the other IP rights that we have here in Jamaica, but this one, creativity and intellect in the context of new plant varieties. New plant varieties, of course, are also important for sustainable agricultural production. In the absence of a plant variety, are reluctant to release plant varieties into a jurisdiction, where there is no such law. Also, does not facilitate or foster competitiveness. And so, by having this new law in place, not only will we have a legal framework which can incentivize plant breeding, but we will also be able to foster a more competitive environment where we can see the production, the creation of new plant varieties on a more regular basis. Of course, new plant varieties also address the need for food security. As the population increases, then there are need for improved products, and so this is also important as we look to the emerging 21st century and the needs of the current population. Environmental benefits also are there for new plant varieties. We can develop varieties which, again, are resistant to things like drought, which can more stand up to hurricane and be resilient in various climates and conditions. We can produce varieties which require lower inputs, which are water efficient, and we can also minimize the harvesting of species from the wild and preserve then our land races and so forth. And so there are multiplicity of, let's say, benefits that we can gain as a country, as a nation, from improved plant variety protection, from an increase in plant breeding, of course, in the protection of plant breeders' rights. So the new law, consistent with the international framework, will recognize and grant a breeder's right to persons where the variety that is developed is new distinct, uniform, and stable. And of course, this is again internationally accepted criteria for registration for new plant varieties. We call it a DUS. So we talk about the DUS or the DUS in terms of the plant variety program. We're talking about the distinctness, uniformity, and stability of the variety. PBR, Plant Breeders' Rights, and UPOV, of course, is the International Convention for the Protection of New Varieties of Plants. So when we talk about DUS, under the bill, a variety shall be considered to be new if, at the date of filing, the application for a breeder's right, propagating or harvesting material of the variety has not been sold or otherwise disposed of to other persons by or with the consent of the breeder or his successor for purposes of exploitation of the variety in Jamaica earlier than 1 year before the application was filed. And that is, an important thing to bear in mind. That when we say new, it means that it will not be granted on existing or pre-existing varieties which have existed for some time prior to 1 year before filing. A territory, in terms of if the variety is made available in a territory outside of Jamaica, then there'll be a 4-year period there that you would still be able to claim it as new. In the case of trees or vines, then it's creation of new creativity by granting you this plant breeder right. So it's not going to deal with existing varieties, but the new variety that you can come up with by virtue of your skill, and is clearly distinguishable from any other variety whose existence is a matter of common knowledge. So again, distinctness is another main IP criterion against this, and that is important as well too, so that the variety can be distinguishable from others in the marketplace. A variety shall be considered to be uniform if subject to the variation that may be expected from the particular feature of its propagation, it is sufficiently uniform in its characteristics, so that it will essentially have a particular look, and it will be uniform in the context of when it is grown, how it is represented. It should also be considered to be stable if its relevant characteristics remain unchanged after repeated propagation. It's a rocket science, competition. It's really geared towards facilitating what many of us have been doing for some time, but again, with a more emphasis and focus on developing new varieties. As we talk about distinctness, here we can see that in terms of distinctness, it should be able to be clearly distinguished from other varieties, whether by its look, shape, its color, etc., which is distinct and can be distinguished easily from other existing varieties. Here we see the color is the main distinguishing feature here. In terms of uniformity, a uniform variety up the top there, you see that it is replicated, that the plants or the crops are looking the same, they're uniform in look, whereas in the bottom picture there, lacking uniformity, we see that sometimes they come short, some tall, some red, some pink. It will therefore not meet the criterion for uniformity. Stability, etc. We see that the variety is stable, producing the same look across several generations. Whereas in the bottom half of the screen, the slide, we see that the unstable variety over the course of generations has changes. Similarly, we see there are some changes in the color and so forth. Over time, it would not be stable and would also not meet the criterion for stability. So not a very stringent threshold that I would say that difficult to meet. Again, of course, once you know the key elements in plant breeding, you'll be able to satisfy the criteria. So how would you apply for the grant of a plant breeder's right? What is the procedure laid down in the new law? So the new law provides for the application process to be made to apply to JIPO, to the Registrar of Breeders' Rights at JIPO. You have to fill out the required forms to apply. That would include, of course, the name and the address of the applicant and the person who bred or discovered and developed the variety, right? So the applicant could be the breeder, or could be someone who the breeder has authorized, who has gotten an assignment from the breeder, perhaps, or if the breeder works for an organization. It could be that organization as well who has rights to the grant. And you also have to, with the application, submit the variety denomination, right? Which is essentially the name that you are giving to that variety, which will again help with its identification and help with this being distinguished from other varieties in the marketplace. Right? Of course, you have to outline in the application the main characteristics of the variety that, of course, meet the criteria for distinctness, uniformity, and stability. And in doing so, you will be asked to complete that technical questionnaire for the relevant genus or species to be able to again. As with the other IP rights, the law will allow persons in the public to be able to oppose the grant of a plant breeder's right. If it is that they think that the person who's applying isn't entitled, or that for some other legally sound reason, the applicant should not be granted a plant breeder's right, maybe because it doesn't meet the criteria, that will enable a third party to file an opposition to the grant of your plant breeder's right within 3 months of publication of the application. And of course, they have to pay a fee to be able to oppose, and they have to file with the registrar a written opposition on any of the following grounds. I said that the applicant is not entitled to the application, or that they could be the basis of an opposition to the grant. And so it works both ways. That if you feel that someone else is applying for what you think is yours, or you have an interest in, you can also oppose, and that will be able to have the rights rationalized and go through a process where it will be put to a hearing, which the registrar will conduct to rationalize and resolve the opposition. So if there's no opposition, or if the opposition is resolved in the favor of the applicant, then the plant breeder's rights will, of course, also then come into play in terms of what the right will entail for the holder of the right. The holder of the right under the new law has the exclusive right to control the production or reproduction of the variety, the conditioning for the purposes of propagation of the variety, the sale or any other form of marketing of the variety, exportation or the importation or the stocking of the variety for any of the above purposes. And so really, the scope of the right gives the owner of the rights to control all exploitation and commercialization, essentially, of the variety within certain countries. There are exceptions to those rights, which are primarily to encourage creations. And so exceptions to the plant breeder's right include that you of the owner of the plant breeder's right in a limited set of circumstances. One, where you're breeding other varieties, so again, you can use it to facilitate existing research that may be done. You want to use an existing variety to experiment and to see what can be produced as your new variety. You are able to do so. Acts done for experimental purposes, amateur gardeners, similar purposes, subsistence farming and that kind of thing. Also done primarily for small farmers, right? The farmers' privilege, as it's called, where small farmers are able to, again, use in certain contexts the protected variety. So this is an important exception as well for us in Jamaica too, because it's a balancing act between the granting of the rights and, of course, the public interest in the exceptions that are permitted. So for small farmers, the breeder's right shall not be infringed where the small farmer, within reasonable limits and subject to the safeguarding of the interest of the breeder, uses for propagating purposes on the farmer's own holdings, land holding that is, the product of the harvest which they have obtained by planting on their own land holdings, protected variety, or a variety essentially derived from the variety, or a variety which is not clearly distinguishable from the variety. Then in those contexts, again, in those parameters, the small farmer can continue to use. This is generally called the farm safe seed exception, which again is a long-standing tradition in Jamaica and elsewhere, where farmers tend to plant and grow and save seed for further crops in the future. It will not permit the exchange and such of farm safe seed, but it will permit the use by the farmer of farm safe seed that he has obtained through growing on his own lands, right? His own holdings. So that's an important exception for small farmers. It will exclude from the exception varieties of ornamentals and forest plants, so that in terms of the limits, it's going to be only applicable to non-ornamental and non-forest plants. And the minister will be expected to stipulate in further regulations the conditions as to how this exception will be implemented in terms of the list of agricultural genera and species to which the exception with the policy, and to incentivize again small farmers and breeders, etc., so that we can generally see a shared benefit, from plant breeding in this context. Person to whom a breeder's right is granted in the law, name and address of the person who bred or discovered and developed the variety, right? So note, it said that you can be either the breeder or somebody who had discovered an existing variety but developed it further, right? And we also include details of any submission, registration, change, or cancellation of the variety denomination, as well as any nullity or cancellation of the breeder's right and any change in the holder of the breeder's right. So just like we have a trademark register, patents, designs, etc., we'll have also a breeder's rights register under the new legal framework. So IP rights generally, tend to have a period where they will expire, and so the same will be in place for this new IP right. It will vary from 20 to 25 years. So it will be 25 years in terms of protection for vegetatively and seed propagated species, including vines, fruit trees, ornamental trees, and their rootstock. And for other genera or species, not included in the above, it will be valid for 20 years. And so again, you have that period of time in which you, as the holder of the breeder's right, can commercialize, can license, assign, negotiate, have contracts in place, and essentially earn from your new plant variety. Exhaustion of breeders' rights is also important as well. Balance the rights in the context of saying that once any material derived from the said material of the variety has been sold or marketed in Jamaica by the breeder or with his consent, then the breeder's right will be exhausted. And so after that, it will permit persons in Jamaica who may want to import protected varieties from overseas and to also sell them, to also do so as well, so that we'll have the opening up of additional income streams, industries. Once we, of course, have the law in place, we will be able to attract foreign breeders and rights holders to bring their varieties here, after which we will be able to have them and access to them for us to be able to develop and also grow our local plant breeding programs, and to also, of course, facilitate other kind of commercial activities, once those rights are exhausted in Jamaica. Infringement of breeders' rights will occur, of course, if it is that anybody does anything with the plant variety that is not consistent with the right holder's rights or the scope of the right holder's rights under the new law, that will constitute an infringement of the plant breeder's rights. And that will therefore be actionable by the plant breeder in court to get compensation, to get an injunction, or other kind of legal means to enforce his rights through the legal system. This is also important, of course, as well, too, because having spent the money to invest in plant breeding and to develop new plant varieties, the law must protect those rights and must give the rights owners legal means to enforce their rights as well. So infringement is clearly laid out in the law, and that will give rise to enforcement measures that can be taken by the owner of the rights. This under the law will also exist as well, so that the law is offenses for persons who willfully offer for sale or market propagating material of a protected variety in Jamaica without using the registered variety denomination. So again, a means of trying to, as it were, sell without being recognized or authorized to sell, making use of the variety denomination for another variety, willfully making use of a denomination likely to cause confusion with the registered variety denomination, willfully making use of the variety denomination for another variety of the same botanical or related species, and also be shown to be criminal offenses where it's done willfully. And of course, where you make a false representation that a plant variety is a protected variety where it's not, that will also be. So the cancellation of plant breeders' rights. Plant breeders' rights will be able to be cancelled. So after the rights have been granted by the opposite, you can also cancel the plant breeders' rights after it's been granted if you feel that it should have certain information that has been granted in the first place or by the registrar on his own of the breeders' rights, where it's not now very distinct or it was not at the time when it was applied for, and you think that it should not have been granted in the first place. It's what we call a nullity. And that is also going to be based on filing with the registrar the right. For the denomination should have been granted. Maybe it infringes some other IP right, like a trademark, etc. Maybe you call your particular variety, let's say you call it James Brown 1, for example. You find out that there is a James Brown trademark or design or the registered, and that may cause a conflicting IP situation. You can also apply to have the denomination of the variety cancelled as well on that basis. Compulsory licenses. So the government does also have the right under the new law to issue a compulsory license, again, through the court system in the public interest, where, there is maybe some useful plant variety that can help with the nation's, ailing healthcare system or some other natural disaster or something. We can apply to the public, to the court for in the public interest to have those rights also permitted to be used by virtue of the court granting a compulsory license, as well as this is also again in the public interest. They provided more details to these possible regulations under the minister's authority. So just to wrap up then, in terms of implications for Jamaica, the IP register, the Plant Breeders' Rights Register in Jamaica, and this is of course a big plus, I think, for local plant breeders. They have access, of course, as well to UPOV, to better varieties which will come into Jamaica, better, greater yields, more disease resistant, and so forth. We also, of course, incentivize hopefully local breeding programs, leading to increased exports and revenue for us here in Jamaica, for plant breeders and for the government as well. It will improve food security, sustainable agriculture as well, increase agricultural research and innovation, improve healthier food products, more resilient food crops, etc. And we also, of course, put Jamaica as a part of the international agricultural development for the Caribbean and the world in the context of plant breeding programs. We also, through this new law, get access to UPOV tools, including UPOV Prisma, an online tool to assist in filing plant variety applications, also the UPOV IT packages, etc., to assist with a global landscape and access to information concerning plant breeding and plant varieties globally. And so for us here in Jamaica, we really see this law as being something that is a game changer for plant breeding in the country, only for cannabis, but also for other plants and varieties which we know we have a great interest in and a great reputation for in Jamaica. And so we hope that through this new law, we can maximize IP benefits available nationally and internationally to plant breeders. So thanks very much. I'll be glad to answer any questions in the discussion coming up.
Thanks very much, Marcus, for that really great and informative presentation. The Protection Office of the United States Department of Crops, Foxes, other turf and forage. And his previous career experience was with wheat and greenhouse crops and their bacterial and fungal pathogens in various states and also parts of the continent of Africa. It is our pleasure at the Jamaica Intellectual Property Office to welcome Mr. Chocolate this morning to share with us the plant variety examination process for hemp in the United States.
Thank you, Madam Director. I'm not used to addressing international audiences, so I don't know if I can't see myself. I suppose you can see me. Is that correct?
No, we're not seeing you at all.
Me at all.
I'm gonna close my camera.
Wait a minute, maybe this is, there we go. Okay.
Nope.
There's my camera.
No, I can see.
There's my camera.
This is fantastic.
I am not in this beautiful office surrounding. I'm at home at this point. We've been home for 2 years now. As you said, I am with agriculture, and let me see if I can work this sharing. And can you see that now?
Yes, we're seeing it. We're seeing it.
Okay. That's my point. The Plant Variety Protection Office is part of the Agricultural Marketing Service, or AMS, of the United States Department of Agriculture. And I'm an employee of that, and we work with plant variety protection. It is not called plant breeders' rights in the United States. The United States system is a bit more complicated than, as far as I know, all other countries that are members of UPOV. So I'm, limited in my knowledge of all other countries because of its history. The plant patent law was established in the 1930s, and it was not until 1970 that the Plant Variety Protection Office was established. So there is a division within the administration and granting of plant breeders' rights, intellectual property rights for plants in the United States. So it's a little complicated just to start off with. The older office, the patent office, is part of the Department of Commerce. And there is patent law, and that governs what we call utility patents, which can cover a number of different things, including plants, various inventions, and then there are specific plant patents. And when that law was established, it only governed asexual, and continues only to govern asexually reproduced plants, clonally produced plants. The Plant Variety Protection Office was established in 1970 with a law, the Plant Variety Protection Act, which covered the other plants, seed and tuber propagated plants, like small things like corn and wheat and soybeans and rice. But there has been a change in the laws with the Farm Bill of 2018. We are now include in our purview asexually reproduced plants. So we can get and have received applications for both kinds. In general, both of our offices, the United States is a signatory to the UPOV treaty. Both of our offices operate in general harmony with the UPOV treaty and the laws and regulations that you have adopted based on the treaty. But again, we have this pre-existing situation, and there are some slight differences between the two offices. You will see down there at the bottom, in addition to which plants are involved in getting patents or PVP certificates, you see that we have the same provision in the PVP office that is incorporated in the Jamaican law that, and I believe is common to UPOV countries, that applications can be accepted for varieties sold in less than 1 year in our country, but 4 years internationally. And this does not include the special exception for woody plants and trees where it's 6 years. So ours regulation is similar to that for Jamaica. Whereas with the patent office, it has to be filed within 1 year of the sale wherever it was sold. So there's a bit of a difference there. There are some other differences, especially I don't really want to get into essentially derived varieties because I know the definition of that is changing a bit. There's still discussion about the issues with respect to essentially derived varieties, but you see there is a difference. In one case they're not discussed, in the other case they are. So there also is, with the system in the US, no national register of plant varieties. There's no national list. Some of the names of varieties have to be approved. That is for seed propagated plants. So of course it affects primarily the Plant Variety Protection Office, because we are the ones who deal primarily with seed propagated plants. But there is no national list of all accepted plant varieties. So you don't have to go through that process. The system, the criteria of new, distinct, uniform, and stable is the same, except that the examination is the same, but the examination process is different because we do not, in the United States, at this time, do trials of our own. For both the Patent and Trademark Office and the Plant Variety Protection Office, the examination is what you might call on paper, or it was before we graduated to electronic devices. And so now it's on the screen as far as records and the information that is presented to us by the breeder in the application. We do not grow out the plants, though there is a possibility that we are moving somewhat towards that experimentally, but it's certainly not a system that operates now. Oh, let's see. Now to start, because I'm talking about cannabis and hemp, we need to have some definitions established, because I'm not sure I understand the situation in Jamaica that everything is considered ganja, but there are legal distinctions made in the United States. Industrial hemp as a crop is defined by, again, the 2018 Farm Bill as cannabis sativa with no more than 0.3% delta 9 THC, that specific cannabinoid, in the material, whatever parts of the material you're talking about, from roots or stems to flowers and leaves. So anything else, and the 2018 Farm Bill, that recently, previous to this, industrial hemp, anything like that, would have been illegal. Growing of industrial hemp was given to the Agricultural Marketing Service to regulate. And so the AMS worked on the regulations and established them in a final rule in the spring of last year. So we're still talking about a fairly new system here for industrial hemp. In the federal system, again, you have to remember that the United States is composed of 50 states and the District of Columbia and a couple of territories, and they can have their own laws within their jurisdictions. Federally, all other cannabis that has more than 0.3% THC in it is marijuana, and it's illegal under federal law in interstate commerce. However, 18 states and the District of Columbia, the capital, have legalized marijuana within their jurisdictions. So that if you're operating within the state, that's okay. It's a question of when you move out of the state, when you try to do interstate trade or transportation, then it's another problem, definitely a problem. And 19 other states permit the use of medical marijuana. That is our system, federal system. You'll notice that 19 and 19 do not add up to the 50 states. Actually 51 with the District of Columbia. There are 13 other states that either continue to make marijuana totally illegal or have some slight exceptions. So there is an evolving situation. It continues to evolve. These numbers could have changed this morning in some states. So the legal situation with respect to marijuana, and even with industrial hemp, again, the laws are different in the different states. The AMS rule governs interstate commerce. Now, having said that, with respect to the definitions of types of cannabis, I am grateful to a lawyer for providing me with this comparison of the types of cannabis protection that are available under our system in the United States. You see at the top that there are 2 types of patents available from the US Patent Office. And then in the middle, there's the PVP certificate that is available from the Plant Variety Protection Office. Plant Variety Protection Office, excuse me, operates only with industrial hemp, only with the crop that is legal in interstate commerce. And because of the other change with the 2018 Farm Bill, we can grant certificates to both seed propagated and asexually propagated varieties, and we have. We do require a deposit of germplasm as part of the application process, and seeds go to a national repository in Colorado. And at this point, we're still figuring out how to handle deposits for asexually propagated plants, because that's a little complicated and requires substantial more work to maintain them. And our protection involves, as I showed earlier, both the cultivar itself in the various means of commercialization that Dr. Goff referred to earlier, and also protects from persons creating a hybrid from the variety and essentially derived varieties that are created from the cultivar. And our certificate is good for 20 years after issuance, that it does not include the application period, which can be, say, from 6 months to 2 years before you are granted a certificate. It depends on, in part on the crop and also on the cooperation of the applicant, how long that process takes. But once the certificate is issued, it's good for 20 years. And and again, there's that exception for woody plants and vines that lasts 25 years, just as in other UPOV countries. Now, I'm sorry there's not somebody here from the patent office to present their point of view. I cannot claim expertise in patents. So you'll have to go with what I can provide in terms of a precise comparison to plant variety protection. Again, you have to apply through the patent office in the Department of Commerce, not in the Department of Agriculture. A plant patent, which covers the variety itself, you can get a plant patent for hemp or marijuana. Even though it's illegal in interstate commerce, you can get a patent on it. You can protect your intellectual property. But again, this only refers under the plant patent law to the clonally or asexually propagated varieties. There's no deposit required, which, as again, I said, there's this difficulty with handling seeds, and it only covers the cultivar which is named in the patent. And the patent, again, has a duration of 20 years from the date of filing, not from the date of issuance. So you hope that the application process proceeds fairly rapidly. With respect to what is called a varietal utility patent, a utility patent is offered to all sorts of inventions, things that are useful. That's the whole idea of protecting intellectual property. And you can get a utility patent for hemp. And that you can get that for both seed and asexually propagated plants, because we're not talking about plant patent law, we're talking about the older patent law. There is a deposit required in this case, of course, and that's going to present some difficulty with, again, the deposit of asexually propagated material varieties that do not produce seed that will reproduce the variety, that you have to propagate it clonally. And so I don't know quite how they deal with that. There is a germplasm bank being developed under the USDA, which might accept these tissue culture deposits. I don't think they're going to maintain plants clonally in a greenhouse, but that's not up and available yet. And the utility patent, depending on how it is written, can cover much more than the cultivar. The utility patents that I've read have been much longer than a plant patent, and they have had more claims in terms of what the intellectual property consists of, whether they're talking about being able to create mutants from it or the methods of breeding. There are a lot of more claims and a much broader protection. As the lawyer who presents this says, the wall lasts for 20 years from filing, but there is the difference with the utility patent that it requires not just the deposit, but a maintenance fee, which is paid in periodic installments, so that after, again, I not my expertise, but they're within those 20 years, something like 3 years and 10 years and 15 years, you are asked to pay this maintenance fee. And of course, if you don't maintain the fee, then or pay the maintenance fee, if you don't maintain the patent, then that's the end of your protection. So there's more to the cost of the utility patent than just the application fees. In addition, with the utility patent, you must file electronically through the patent electronic system, or there's an extra fee. or filing on paper or over the internet through email. So that adds to the cost. Now, with respect to the plant variety protection system, we ask now for a one-time payment of $5,150 that's required at the time of filing. We used to split it up, but that was a little more difficult. And since the majority, or the more than the majority, most applications are rewarded with a certificate, we decided that it was simpler to return the certificate preparation. I mean, to have the certificate preparation fee paid upfront at the time of filing, and then if we don't approve it, then that certificate preparation fee, which is about 1/10 of that, is returned. So that's it. There are no maintenance fees. There's no fee for filing non-electronically. However, again, the difficulty of vegetatively propagated plants, which includes tuber propagated plants, there's a fee required for the labor and costs involved in creating a tissue culture that can be preserved frozen. So for tuber propagated plants, which we're talking primarily about potatoes, which is traditional, but it would possibly in the future involve clonally propagated industrial hemp, there would be an additional fee. So there's no fee for depositing seed. It's just cost of sending that seed, or the cost of the seed, which I understand in some cases of some cannabis varieties can be a bit much, but also just beyond that, just the cost of sending however many pounds of seed are required to the repository. Well, yes, we're still working on what we will do with the asexually reproduced varieties of anything, including industrial hemp. We like to think that our system is simpler than certainly than the patent system. You are not required to be a registered agent or an attorney in order to apply to the PVPO. Again, we like to think that our applications are simple enough that an ordinary person can complete them, but many applicants do use the services or of a patent attorney or a patent agent. The utility and plant patent costs vary because you do have to have, in general, a plant attorney or patent attorney or agent to do the application. And I, having looked at just a little bit of patent law, it's my recommendation that you do that because it's complicated and there's a lot of it. But it is possible to file for by yourself with the patent office, what they call pro se, but it certainly would be advisable to have the advice or training or something from someone who is registered with the patent office, in my opinion. Again, we don't have anybody from the patent office to disagree. And again, our application forms are simple, relatively simple, and we have a form for the description of the variety. You complete the form, whereas in the case of the patents, that is more of a free form description. Obviously, there are things that you have to cover, rules about how you can say things so that they're correct, but there's not a form to complete. So again, it helps to have someone who's experienced. Our Exhibit C form for industrial hemp, as with new crops, especially the vegetatively propagated crops that were added a couple of years ago, follow the UPOV table of characteristics. And so we ask primarily the same questions that are in the UPOV table of characteristics, though we do add some and might come back to the applicant and ask more if we are as necessary in the examination. I will make the point that at this time there are all three kinds of protection for hemp, specifically for hemp. Of course, again, we cannot in the PVPO deal with marijuana, but there are a good number of plant patents for marijuana varieties. Again, the question is what laws govern what you're doing in the specific state, since marijuana is still illegal in interstate commerce. Now, I cannot, again, not being from the patent office, go through the, I presume, expect lengthy process to apply for a patent. But I can tell you about applying for PVP and what will happen after that. Again, we do not do DUS grow out trials and examination of the plants ourselves. We have a small office. There are only 10 of us in the Plant Variety Protection Office. And we do not have a greenhouse, even have a greenhouse, much less acreage on which to grow plants. So the applicant will have bred a new, distinct, uniform, and stable variety and completed their own DUS trials involving the new variety and comparison varieties. They have to have at least one comparison variety, but some that I've seen have maybe a dozen comparison varieties in the same trial. Also, as with the Jamaican law, there has to be a unique name for the variety, and if it's a seed propagated plant, that name has to be approved. If it's not a seed propagated plant, we will do a search to look for, to check for the uniqueness of the name, the lack of conflict or confusion with another name. We do have an electronic system, just as does the patent office. It's fairly new also. I won't say that every single part of it is up and running, but you can, from Jamaica, access this system and use it to file an application. Obviously, you can't submit a deposit electronically. They actually have to physically send seed to Colorado, but that's essentially the only part you can pay the fees through this system and see what's going on with your application. You're not restricted to this system, just as you aren't restricted in the patent system. You can still file on paper, or with us at least, sending documents attached to an email, PDF documents, or whatever other kind of documents you might have that you can attach to an email. But this EPV system is a choice available to you. We're encouraging it, but the system in general encourages electronic things these days. Now, here is a general view of how to apply with our system using the electronic EPVP system. So before I forget again, I want to emphasize that, of course, the United States is part of UPOV. You can also use the PRISMA system to apply. But if you go through our own particular EPV system, there's a step where you have to establish your identification and register your account with us. That can be accomplished through email from countries, from a location outside the United States. You have the account. You can create the account online, or as I said earlier, you can go to our website and download the forms that you can complete either as paper forms or electronic forms and submit those through email. So you have choices as to how you actually apply. But of course, you have to provide the evidence, because we are not going to do the DUS trials in those documents for newness, distinctness, uniformity, and stability. So I would encourage you, of course, to go to our website and read the materials that are there, just as you should go to the Patent Office website and read the materials that are there if you're interested in applying for either a plant patent or a utility patent. You can pay electronically through more than one means. The initial fee, or the sole fee of $5,150 for the application. You can still do old-fashioned methods like sending in a check. We do still, or using a credit card. We still have a number of choices. I would not suggest cash. And then after the initial processing, the applicant will receive directly or through their agent a filing letter. That will be the first response from us, is the filing letter letting you know the time of the application. The examiner, like myself, then looks at the applications, evaluates it, does a search virtually to compare the variety with other varieties in our database or that can be found online, for instance. And if he or she needs more information, that would be the second time that the applicant would hear from us. We would request information. And if that's approved, the examiner forwards it to the commissioner, and the commissioner looks at it and makes the decision. And if that's approved, then would be the third time that the applicant would hear from PVPO, in that there's a notification that the application has been approved and we wish to check variety name and the name of the owner that will appear on the certificate. It's a physical document, so we want to make sure that that's correct. And so you have a a limited time in which to reply and say whether that information is correct. And after that time period has elapsed, then the certificate is prepared. It is signed by the commissioner and the Secretary of Agriculture and sent to the applicant or the applicant's agent. If you have a clonally or vegetatively propagated variety, at that point, you will be expected to submit germplasm if a repository and a method have been identified by that time. There are a few responsibilities afterwards during the term of the certificate, which, as I said, is 20 years for herbaceous plants and 25 years for woody plants. Okay, that concludes my presentation. Again, I represent the Plant Variety Protection Office as part of the agricultural marketing hemp in the United States, the growing of an industrial hemp in the United States. Thank you for your time.
Thank you so much for your presentation. An agency. He's also Canada's representative to the International Union for the Protection of New Plant Varieties.
Dear Miss Bellamy, I'm thrilled to make connections with my friends at JIPO and all the participants today. It was minus 17 degrees Celsius, so 3,000. Your friends 3,000 kilometers to the north of you would much prefer to be in person in your beautiful country, enjoying a very warm, welcoming environment to be there in person. So thank you for that introduction. I'm going to attempt my attempt at utilizing
Okay.
Okay, can you see that now? I'm going to put up my presentation and we'll see.
Yes, we can see it. It's
yes.
not in presentation mode, but we can see it. Yes, that's better. That's perfect.
Okay, wonderful. So I had some correspondence with Marcus, and I asked him the question, "What would you like me to talk about?" And he provided me with a shopping list. So I'm going to break this presentation into two parts. One is we're going to talk a little bit about Canada's recent legalization of cannabis and the impact that that has had on our sector, both in economic terms, but also in terms of the number of applications that we're receiving for PBR. And then I'd like to move over and sort of share some of our experiences, really almost a little over 2 decades to come into place. It first started in the late 1990s where, public opinion polls were starting to see a shift in attitude around smoking marijuana, quite often a delineation recognizing that there's these things called soft drugs and there's these things called hard drugs, and maybe we shouldn't be viewing cannabis in the same way as we would view something as heroin or cocaine. And I think that was starting to be pretty ubiquitous in the population. After all, alcohol is a drug, and it's been legal in Canada for a very, very long period of time. And we had an Ontario Court of Appeal ruling that the prohibition of the use ruled in its favor. Almost immediately after, the government, the bureaucracy responded and said, okay, we need to really move forward. And came to the forefront with the Marijuana Medical Act. We have a multi-party system, but generally the parties in power are the Conservative Party and the Liberal Party. The Conservative slightly right of center, Liberal slightly left of center, and they campaigned in 2015 on a platform to say if they were to be elected, they would legalize recreational cannabis. And this really resonated with our population. A national poll conducted in 2016 really showed that 7 in 10 Canadians were in favor of legalization. So In 2017, we had Bill C-45 was introduced into Parliament, and it was coming into force date of July 1st, and it would allow recreational cannabis use for anyone who was 18 years and older in possession of up to 30 grams. And really, that decision and the coming into force of the legislation spurred on a whole new industry in Canada with some fairly significant economic impacts. I think this graph kind of tells the story quite well. If you look at the bars on the bottom, starting in the left-hand corner, you can see under the old regime where we recently legalized for medical purposes, we started to see a growth in that industry. It sort of plateaued around that 160, $150 million range in terms of sales. But the moment the Cannabis Act came into force, legalizing it for recreational use, we just saw a spike. So most recent numbers that I have on file here, going back to the second quarter of last year, so 2021, it's really now become a billion-dollar industry in terms of commercial sales. It's almost in Canada, it was almost like the development of the tech sector, where you were seeing, these startups, and there's these IPOs coming to the market. Everyone was getting into the cannabis business. We've seen some consolidation to this point in time. So as would be expected, some of the bigger players have bought out the smaller players. Some of the larger players have merged together. This gives you an indication of who are the private sector players in there. Canopy Growth, often known as Tweed, is the largest player. Aurora is second in line, followed by Hexo, and then a number of smaller entities that are involved in the cannabis, both breeding, but also processing and development and marketing. And I want to spend a little bit of time on talking about this. Is we've seen the development of different strategic IP approaches depending on the company. So I had the pleasure of visiting Cannabis Growth. It's only about an hour, their headquarters, from where I live here in the nation's capital, and it's quite an impressive facility. And they're very much vertically integrated. So they do their own breeding and research. They do their own on-site production. They do all their value-added processing. They do some of their own marketing as well, and then they license out the products for others to sell. And we haven't really seen any applications for their new varieties, because their philosophy is it's the system's closed loop. We're really not interested in disclosure of our inventions at this point in time. Everything's kept in-house, and we feel that there's no real threat at this point in time from someone exploiting our intellectual property. I suspect that's going to change, and as the market gets more competitive, we're probably going to see them come in to do some filings. Aurora is another cannabis company that has a very different philosophy. They do file for PBR quite aggressively. But they've also decided that their competitive advantage is not just to use their own varieties in-house, but also to seek partners externally and license their varieties to elsewhere globally. So they've set up a separate licensing company called OCO, and they pursue PBR not just in Canada, but all over the world. So that gives you an idea of who the players are and the size of the enterprises that are involved. So prior to this presentation, I thought to myself, well, I'm going to go, place some calls to the leaders in the cannabis industry and get some insights, because I don't know, I'm not an expert on cannabis. Where are you going? What's your future look like? And they were quite kind to take my call and spend a few minutes with me discussing where they see their industry heading in the future. Vertical integration is kind of here to stay with them for now. It's very profitable, that model. They're looking for lots of new opportunities to diversify and differentiate their products in the marketplace, both for THC but also CBD products. This expands beyond what we would know as, things like the dried flowers to, and it's very pervasive in our marketplace right now, is edibles, things like cannabis mixed with chocolate or gummy bears. Vapes have become very popular, pre-rolled products. They've got into the beverage business now as well. So you have, THC spiked beverages, oils and concentrates, and the soft gel capsules. So you sort of have to understand that we've moved beyond just smoking it to a whole product line of value-added diversification, and that looks like their future, and that future is here to stay. They're very interested in lowering production costs. So right now, everything's done in greenhouse settings, very expensive, especially in a climate like Canada, where you have winter for 6 months of the year, 5, 6 months of the year. And moving from an asexual propagated production system to outdoor seed reproduced. Of course, that has its challenges associated with it. Once you leave the greenhouse or a very secure, controlled area, you are now in the open. How do you provide security and protection for your highly valued product? We've seen a real shift in the professionalization of the breeding sector. It really, lifted it from the basement breeding and the criminal aspect to come to the forefront for intensive R&D investments. So we have some quite impressive breeding facilities for cannabis, both at Canopy Growth, just to south of Ottawa here, but also in the West Coast in British Columbia, on Vancouver Island Comics, where Aurora is based. It is quite state-of-the-art facilities for research and development, and really pumping out new varieties on a continual basis. No surprise, aggressive use of IP layering. So it's not just PBR for some of them, but seeking trademarks and also patents on some of their exclusive traits and processes. So we have also seen an evolution where these companies are looking beyond the Canadian landscape. My friend David in the States, they're eagerly awaiting legalization in many of the states to make some inroads there, but also globally. And it's not just for their products, but also looking to move their production to more cost-effective, lower cost locations than Canada. Although we suspect the R&D arm will always sort of remain headquartered for many of these companies in Canada. So if you want some more information as you go through the process of legalization, I really encourage you to visit our website. Health Canada has a list, a lot of information on how Canada regulates cannabis. You can see our act, there's guidance. You can understand the process by which we issue licenses, both for sale, but also production of cannabis. So there's a real wealth of information. I encourage JIPO, if you want to follow up with me afterwards, I could always put you into contact with some of my colleagues in this department. So to date, we've seen a growth in plant breeders' rights applications since 2018. It's been relatively modest at this point in time, but we also have to understand that the development of new varieties takes a little bit of time. The material that these sectors were working with was really sort of underground material, let's say, and wouldn't have met the merits of being new. First of all, right? So anything that's been previously commercialized would not, prior to 1 year in Canada, would not be eligible. So it takes a little bit of time for these facilities to ramp up their R&D efforts, to ramp up their breeding efforts. But now we're seeing sort of this continuous stream of new varieties coming into in for PBR protection, at least for those companies that see it as part of their value proposition to seek PBR protection. And we feel this is here to stay. We're only going to get year after year an increasing number of applications. Now, from a technical perspective, this doesn't worry us very much. We've had 3 decades of experience working with doing DUS assessments on industrial hemp. The switch to doing assessments on cannabis for recreational purposes really isn't a large stretch for our office. So we're well equipped to deal with it. We also, and this is one of the advantages that Leontino spoke to earlier, is once you become part of that UPOV family, the level of technical expertise and experience that you can leverage from other national authorities is quite useful. A world leader in terms of doing assessments on DUS is the Netherlands, the Nachtenbouw. We've had a lot of conversations with them about what happens when you experience this sort of situation or this characteristic of trait. So certainly one of the benefits of that UPOV family is the ability of new member countries to leverage the expertise of others to help them do their technical assessments. So maybe a little bit about our experience implementing UPOV, and I hope this provides some useful insights to Jamaica as it embarks on its journey. As you can see from this poster here, us Canadians, if you have 6 months of winter, you have to have a sense of humor, and often a sense of humor about yourself. Our journey to join UPOV was a difficult one. We first became interested in the late 1970s to join as soon as the 1978 Act came into force. And we tried tabling 3 times legislation in Parliament during the 1980s, and we failed. We finally made it on the 3rd try in 1990. And there's various reasons for that. IP can be a very controversial subject, and IP in its association with plants is a very controversial topic. And I think the bureaucracy at the time, nor the political level, anticipated in advance how controversial it could be. So my cautionary tale a little bit is to say, tabling a piece of legislation is one thing, but making sure that you shepherd it through to coming in force is quite another thing. And I think it would probably be worth some time if I talked a little bit about some of the things that we did to ensure that we were successful, first moving to UPOV 78 and then moving to UPOV 91. But certainly for Canada, the intent 30 years ago when we passed UPOV 78 was to stimulate investment in plant breeding in Canada, was to provide Canadian producers, so our farmers, with better access to foreign plant varieties. No one was coming and bringing the material to Canada because we did not have any IP rights to protect them, and also facilitate the protection so our breeders could now be putting their material out in other jurisdictions, entering into licensing agreements and collecting royalties. And in fact, 10 years after passing the legislation, we conducted an impact study, and it fulfilled all these intentions. And we felt we've been very successful and have grown our agriculture and horticulture sectors because of this. That report actually played a very important role to stimulate discussion to say, we need to actually move farther past UPOV 78. It's a weaker form of IP protection. We're starting to see some difficulties, some gaps. We're being looked over for foreign direct investment. We're being looked over for the bringing new varieties. So that was the impetus in 2015 to move to UPOV 91. And again, we're right now in the process of conducting an impact study to assess those results. And once again, it's looking very promising for us that it was a good decision and we're reaping benefits. Now, I'd be remiss if I didn't talk a little bit about some of the controversy that one faces when it comes to IP protection in the plant world. And I think much like Jamaica, Canada is a liberal democracy, a pluralistic society. We welcome the views from everyone. But what we found is when we started discussing the move to UPOV 91, we met with a lot of resistance from non-governmental organizations and a very small segment of the farm population that had different views than the adoption of IP rights to stimulate investment and innovation growth in our agricultural sector. And that's fine. I think it's very good to have that plurality of perspectives. The challenge we experienced, though, is the narrative coming from the anti-IP views was not actually factually correct. And it was putting a lot of fear in the majority of farmers and farm organizations around the decision to move to UPOV 91. And I think one of the different approaches or tacks that we took was to actually do outreach with every producer group, with every farmer association in Canada, and there is quite a lot of them, to go out and say, you know, we are at your disposal to provide factual evidence-based information about what this would mean to move to this. And I think it instilled a lot of comfort within our farm groups to understand, you know, it's not big bad man Monsanto coming to steal your land races or anything like that. It's that here is the checks and balances in the IP regime. You can opt for varieties that are protected or ones that aren't. The real motivation on this is for development and prosperity in our agricultural sector, which you as a farmer will benefit from. So I think that change in approach really won over that middle majority of the farming community to the point where they actually came to government's aid. And this is really important at the political level to say, look, we support you in your decision here. So I encourage you to have a look. They generated a website called Partners in Innovation. And as the bill was moving through Parliament to strengthen our PBR law, what we saw is more and more farm groups coming to the aid of government, coming to the aid of the political decision makers to say, we think that you're doing the right thing here. We think you're making a step in the right direction. And that really turned the tide of the perspectives around the utilization of IP rights. So a little bit about our Canadian PBR framework, and it truly is a partnership. And I think to understand that partnership, one would have to understand the time that our office came into existence. So in Canada, the early 1990s was a time of fiscal restraint and austerity measures. We were just in the midst of a sort of a localized recession, and government really said to the political decision makers really said to the government at the time, the bureaucracy, you know, we'll support the bringing into force of PBR. That's fine, but there's three conditions associated with it. It has to be effective, and it has to be have a low administrative footprint, and you have to be funded from the revenue that you generate. So really the option available for us to do this was, at the time, we could not afford the infrastructure for state-run testing facilities like they have in Europe. So what we opted for under Article 12 of UPOV was a mixed model whereby we would have a breeder-run testing system. So instead of the breeder providing propagating material to us to grow out, we tell them how to grow it under UPOV prescribed test guidelines. And we say, we will come to you and do the DUS examination. That's really a cost-effective mechanism to do it. The other element is to say, you know, we took a decision that as long as you're a UPOV member, you follow UPOV testing protocols, you use UPOV test guidelines, we are going to accept your DUS examination reports for most crop types. We have a few exceptions, as being as valid as ours. So a lot of our DUS examinations occur in Canada, mainly for agricultural crops. And a lot of our DUS examinations come from other national authorities who are UPOV members, and that is really crop type dependent. So for things like our ornamental sector, annuals and perennials, flowering shrubs, many of them have been tested in European nations like the Netherlands, their Noctenbau, or the Sortnan in Germany, or Givez in France, and we will accept those test reports as being as valid as our own. The other thing we have a lot of focus on is public disclosure. So if you are interested, please, do a quick web search. Uh, Canada Plant Breeders' Rights Office Plant Variety Journal. So on a quarterly basis, we disclose all the information about new applications that we've received, the details around who the owner of the variety is, who is their agent in Canada, information around how the examination was conducted, and also information associated with the grant of rights. So we've been really pleased with how our system works. We generate about $1 million in revenue a year from filing fees, and our direct costs for salary and our operations are about $1 million a year. So it's a nice balance and doesn't put a lot of pressure on taxpayers to fund this system. A little bit of information on what kind of applications do we receive in a year and the impact of UPOV 91. So in the early late 2000s, early 2010s, we were really at a steady state level of around slightly less than 400 applications a year. Then we were starting to see, with a weaker form of IP protection, our number of applications were starting to drop. We were becoming less interesting to many foreign breeders to bring their varieties to Canada. They viewed UPOV 78 as being substandard protection now, as most of the world had moved on. So once we amended in 2015, all of a sudden we saw the progression of growth again, and we are now back to a steady state level, probably growing a little bit higher than we were before, and we anticipate somewhere around 400 applications a year is where we'll end up on an annual basis. So to give you insights in what do the type of applications look like, well, it's a real diversity for us. Most of them are in the ornamental sector, almost exclusively from foreign breeders. We are fine with that. We do not have a large ornamental breeding industry. We do specialize in hardy roses, so we have one breeding program for cold weather hardy roses that is quite successful, but the overwhelming majority of our ornamental submissions come from European countries or the United States. In the agricultural sector, it's very different. Cereal crops are almost exclusively bred by our public breeders in the university system or in the federal government, and they use PBR. They're quite satisfied with it. Vegetable, almost exclusively, once again, for greenhouse production coming from countries like Germany and the Netherlands. Potatoes are a real mix, and fruit crops are a real mix. So, Canada has taken the approach of we want access to all genetic resources, that all new varieties that can benefit us. We will specialize in certain areas. We will even export to others the propagating material in certain areas, but we want the swath of options available to us. And really, the UPOV system has precipitated that, given our growers a greater diversity and access to varieties than they could have ever had just relying on domestic breeding alone. From an R&D perspective, we have done very, very well. Soon as we implemented UPOV 78 in the early 1990s and then strengthened to UPOV 91 in 2015, we have just seen the amount of R&D, so breeding investments, direct investments into Canada kind of soar. We're up, we started back in the day at 45 million. We're up in about 180 million. That's just private sector alone. It does not capture the amount of investment that's being made by the public sector into breeding crops. And I think that's a very important point is, I would strongly encourage you, if you haven't already, to really investigate how your public sector can benefit from the utilization of plant breeders' rights. So as I reflect on kind of our journey, some of the things that I wish someone had said to me when we started this a long time ago, and maybe this will be useful to stimulate some thought, is, you know, do you have a good idea of what are the policy objectives that you want to use this tool of PBR for developing your agriculture and horticulture sectors? And it already sounds like you have. You know, is this about ensuring a higher level of domestic food security, so self-reliance? You know, are you looking for export opportunities? Certainly, it sounds like you are. Specialization, it seems like you have a natural advantage in ganja or cannabis, but are there other things that you do quite well, or are there other new things that you can acquire to do quite well, leveraging plant breeders' rights? Seeking foreign direct investment or access to new varieties. I can tell you, for Canada, everything changed in these two respects when we implemented the UPOV-based system. In our situation, you know, we had to do a lot of homework. We had to do a lot of analysis to convince the lawmakers, to convince the farming community that this was ultimately in their best interests. There's a lot of good resources, so we can certainly share our 10-year report from Canada, but also on the UPOV website, you see impact studies in various jurisdictions associated with the utilization of IP to stimulate more breeding activity and how that impacts your agricultural sector. There's some great studies from Europe actually recently showing the benefit of how they've improved their agricultural prosperity through plant breeding and the use of IP. Think a little bit about what type of breeding efforts you want and what you could benefit. And I think in our experience, the most resistant parties initially were the public sector. You can understand that a lot of breeders get into breeding because what they view to be a public good, and why should I be seeking IP protection on it? And I would argue that if there's farmers' dollars or if there's taxpayers' dollars going to fund your program, that is, you know, crucial that you have IP protection on it. So those investments are wise investments and they're protected investments. We've had many cases in Canada where we failed to protect a public innovation. It's gotten out of our control. It's gone somewhere else. Someone has now benefited from our subsidization of R&D and is now competing against us. And then we have other situations where the public sector has embraced PBR, has leveraged it, and has become self-supporting through royalty financing, and has actually become a forefront and a leader globally for the work that they do. So, you know, sweet cherries is a great example. Canada is not the most conducive environment for sweet cherries. We only grow 1,000 hectares a year, but we are the global leader in sweet cherry breeding. And we deposit that innovation all over the world. We collect royalties and it funds our competitive advantage. So the best cherry varieties go to Canadian producers first, and then we move those offshore and license them to other parties, collect the revenue, and it really funds all the R&D efforts. I talked about stakeholder consultation. You know, you should also think about strategic communication. IP is inherently controversial. When the resistance comes, if it hasn't already, are you prepared for that? Do you have the messages well thought out? Are you ready to counter the misinformation or myth information about IP with factual evidence, correct information around what IP is intended to do? I would also suggest, you know, if you haven't already thought about it, understanding really those interrelationships between the three different international plant treaties, the UPOV system, but also the Convention on Biological Diversity, which I know Jamaica is party to, as well as the International Treaty on Plant Genetic Resources for Food and Agriculture, which also Jamaica is party to. There's perceived tension points between those. And I say perceived, in our view, these systems are meant to be complementary and mutually supportive. and we have ways of explaining that, but sometimes sadly they are kind of weaponized to be used against and say, well, there's inherent contradictions, and if you're party to one you can't be party to the other. That's of course not the case. So understanding those interrelationships and being ready to communicate externally about them, I think, is really important. And then I'm sure you've already considered the aspect of trade agreements. I know for Canada, as we enter in both bilateral and multilateral trade agreements, we start making UPOV 91 membership as a prerequisite to our IP chapter. Many other nations like the United States and the European Union, we've observed that as well. It is really becoming kind of the new normal and standard baseline. And then finally, administering a PBR office, starting from scratch, it can be a little bit daunting. And of course, as Jamaica becomes part of the UPOV family, don't worry too much. You've got a large network who would be ready to provide assistance, Canada included. If you're interested in our breeder-run testing system, or you're interested around how we take over the US reports, it would be only our pleasure to provide assistance if that were needed. So thank you, Ms. Bellamy. I hope that was informative, and I'll leave you finally with one last slide, which we think we might change to our new Canadian flag. And I know Jamaica has a similar one, so we might be in competition for a new flag design here.
I don't think the maple syrup producers will be happy. Thank you so much for such an informative presentation and for all your offers of assistance. We will definitely be reaching out to you in that regard. Well, we've come to the, thank you so much. It really was helpful and informative. And you raised a number of the questions that have actually been raised by the NGO community. We have had that interaction already. So this really touched on a lot of the areas that we have had to be contending and dealing with. So we would open and be welcome to sharing your information with us in terms of how you have dealt with it.
Absolutely. JIPO has an open door. Please, you have my contact information, and we'd be happy to have a follow-up conversation.
No problem. Thank you. I'm going to open the floor now, and I'm going to invite persons. If they have any questions, you can either place it in the chat, or I'm going to ask Mr. Talbert if he could enable and allow persons to speak. So if there are any questions, you could raise them now, please. Previously, I had responded to a number of questions in the chat, including whether the presentations would be made available. And we're going to put those up on our website. So the entire presentation will be made available at the end. So you will be able to go over, because I know some of our participants had to leave and miss some of the sessions, but some were able to rejoin. So all of that will be available on our website. I haven't seen any questions in the chat. No. Nope. Well, if there are no questions.
Director Bellamy.
Yes.
This is David Shockley in the United States. And I don't have a question. I just wanted to add a little information that I realized that I had been asked for, but I forgot to include in the flow of all my words. That in terms of recognition of smaller enterprises or individuals in terms of costs, the patent office for plant patents and utility patents has a discount for what are termed small businesses and micro enterprises, which would include individuals. The definitions that one would have to meet are of course, a little they're specified so that I can't go into those precisely, but the patent office again does have fee discounts, substantial fee discounts. It's 50% for small businesses and 75% for micro enterprises. Whereas the Plant Variety Protection Office does not. There again, you have our complicated system with two parts with different rules. So I just wanted to, since I had been asked to include that, I wanted to get it in.
Thanks for sharing that information. That really is important. I know Millicent Wallace said she had 2 questions. Millicent, can you type your questions? Because we're having some technical challenges. So if you type the question, I would be able to present those questions on your behalf. Okay, how far along is Jamaica in preparation of requisite examiners, or is this already in place? Oh, that's a question. That's not Millicent. That's from Brian Stevenson. Okay, I'm going to ask Marcus to deal with that question. So, Marcus, how far is Jamaica along in preparation of requisite examiners, or is this already in place?
Sure. Thanks for the question. As we were discussing, there are several options available in terms of how we do examinations of plant breeders' rights. So one is for the office to do its own, testing, which would probably be the most onerous. We could also use test guidelines from UPOV, and then request that the applicants themselves do some testing, some grow testing that we can then monitor and supervise, which, as was shared by Anthony, is very cost effective. And also we have the option to accept examination reports from outside of Jamaica on similar or same varieties, which we can use as well. So we are certainly looking to utilize the last 2 of those 3 options to be able to do so, while of course we continue to grow a local capacity to do our own testing. So that answers the question. I did see a question as well to look there in the question in the audience questions, the icon up top, from Mr. Pinnock, Mr. Mark Pinnock, asking, can you declare that Canada recognized ganja as a product of Jamaica? It's important to mention. So I'm not sure, Mr. Pinnock, what you mean there, but if you can clarify that question, we would certainly want to be able to provide an answer.
Just to add, Marcus, I'm seeing in the chat where some of the questions may be pretty long, but it's okay if you could just modify and include the question in the chat. We will address it. Okay, so here's another question. What about a variety that was distributed on a trial basis prior to formal release? Does this make void the opportunity to license?
Right. So under our bill that is to be law in the near future, you'd have a time frame, where in which you would be able to still have the variety considered as new. And so, if it's a trial basis and it falls within the time frame in Jamaica of 1 year prior to the application, then you would be able to still have it filed as new. But you're asking about the opportunity to license. So, I mean, of course, you'd want to get the plant breeders right first, registered, before you would look to do any licensing. And so I'm answering the question from the perspective of whether it would qualify as being new to be registered for the plant breeders right. Leontino, I saw you coming in, and if you want to add on that, please.
Thank you. Well, it's important that the breeders, they keep in mind that once they sell plant propagating material, or once they commercialize harvested material identified by the variety denomination, this is a very important cutoff point from which the grace period starts to count. So if propagating material is being openly commercialized with the identified, this is when it starts to count for the grace period. And after this question, I received a question in the private chat, so maybe later I could also report on that very interesting question I received.
Ms. Bellamy, Canada could provide some insights on how we deal with those situations if that's useful.
That would be helpful. That
Yeah.
would be useful. We'd appreciate that.
Yeah, so I think we've taken an interpretation that if the act of putting the material in the hands of others are for trial basis only, that would not constitute a sale or an advertisement of it. We look for extra protections from the breeder to things like a non-propagation contract to say, okay, I've given it to someone to test, to make observations, to assess the value of it, but they're not selling it to others. So in those respects, it would not breach novelty in our view. So simply for the purpose of assessment, to take observations, and there was no further propagation or no sale of the material, in our view, would not constitute a breach of novelty. So it would still be eligible.
Okay. Thank you.